As you are aware, IPNet is hosting its 27th webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without further ado, it is my pleasure to invite Mr. Rajiv Kumar Agrawal, member of National Executive Committee and Regional Head of IPNet East, to deliver the formal welcome address. Rajiv sir, the stage is all yours.
Thank you. Thank you, Tina. Good evening, everyone. It's my pleasure to welcome you all. Today's 27th webinar on managing resistance, IP approach to 12-way withdrawals, and non-cooperative promoters. We are privileged to have our chief guest, Senior Advocate Mr. Balbir Singh and Mr. Udaraj Patwardhan as our esteemed keynote speakers. A special thanks to Sri Ashish Makiza, President of IPNet, for his visionary leadership in shaping this platform. The membership link is available in the chat, and we look forward to having you with us. IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning activities like webinars and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, thank you for your support. And for others, I encourage you to join this dynamic network. Membership details are available in the chat. Thank you for being here. Let's make this session insightful and rewarding. We are deeply saddened to hear about the passing of Mr. Harikishan Gupta, father of our esteemed IPNet member, Mr. Mahesh Gupta. In this moment of grief, we extend our heartfelt condolence to the bereaved family. May his soul rest in place, and may the family find strength and comfort in this difficult time. May I request all the members to silent for 15 to 20 seconds in this. Tina, please proceed.
Yes, sir. Shall we proceed with the intro video?
The fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Sir, I would request now Mr. Vivek Chirania to introduce our chief guest.
Thank you, Tina. It's my pleasure to introduce Advocate Balbir Singh. Mr. Balbir Singh is a distinguished legal professional from Chandigarh, India. He graduated with a law degree from Punjab University between 1993 and 96. From August 2006 to December 2014, he was a partner at DSK Legal. In January 2015, he began practicing independently as a counsel. He is among the youngest lawyers to be designated as a senior advocate by the Delhi High Court. Additionally, he has served as a senior standing counsel for both the Income Tax Department and the Competition Commission of India. Notably, Mr. Singh is a first-generation lawyer. Beyond his legal career, Mr. Singh is an avid cricketer and maintains a rigorous fitness routine, running regularly regardless of weather conditions. He has also been associated with the Faculty of Law at the University of Delhi. Early in his career, around the age of 26, Mr. Singh successfully challenged a provision related to the excise taxation system on steel manufacturing before the Supreme Court, resulting in a stay on the provision. This achievement significantly elevated his profile within the legal community. In July 2020, Mr. Singh was appointed as an additional Solicitor General of India for the Supreme Court. After serving for over 3 years, he resigned from this position in January 2024. Following his resignation, he resumed practice as a senior advocate. Thank you. So the stage is yours.
Thank you very much. First of all, I'm absolutely grateful for the invitation by IPNet. But I need to certainly go back to my office who has given this resume, because they have gone back saying that what I was at 26 years of age, which I also don't remember. But anyhow, that's on the lighter side, I take that. What I generally believe is that I would never have imagined pre-2016, pre-code, that the Insolvency Professional Association or any kind of a body could take this kind of a shape. I would never imagine. And I don't think anybody will imagine that this is the role given to the professionals under the code is going to take such a significant step. So first is, I must congratulate all of you that you are doing a commendable job, and putting such complex law in place, which I would largely say has emerged as a successful law in the country. Because it is not easy for any new law, such complex, where the stakeholders have got multiple interests. And a professional can do a role where the closure can be achieved. I can understand there are going to be multiple stakeholders, there are going to be multiple issues, and the multiple adjudicatory authorities and the appellate authorities created, the issues will be there. But for any law to succeed, and especially which has got the domain of adjudication plus regulation, to succeed in the country, the role of the professional who has been given to drive the process is extremely important. And overall, when you look at it, we can have multiple ways to criticize it, but I think overall it has worked extremely well. And I think resolution professionals have played a very, very key factor in this. What I personally see the role of RP or the insolvency professional is like a pilot driving a plane through a rough weather. And why I say rough weather is because any insolvency means there's something gone wrong with the corporate debtor, and corporate debtor is not in the healthy position, and stakeholders are gunning for blood. And therefore, it is to be finally resolved and to be a destination where the process can reach Section 53 stage, where the resolution can be achieved finally and the closure can be achieved. It's not an easy process. Since 2016 to date, with 25, in spite of multiple court intervention, multiple processes being given by the board, and multiple amendments made based on the experiences which emerge in the process, still I think there are certain aspects which certainly we go and take back to the court. And I see on a daily basis, seeing the court struggling with various aspects, maybe on a commercial landscape, or maybe from a regulatory point of view, or maybe the legal process which is there. And I don't see it ending, because the simple reason is that the stakeholders have got conflicting interests. And the center force of the entire this process is the resolution professional. It is going to be allegation or a counter allegation against the professional saying that he's siding with the promoters, he's siding with the COC, he's siding with the successful resolution applicant, and so on and so forth. So therefore, it is always going to remain a challenge for the professional to drive the process smoothly, drive the process fairly, and getting out of the process unscathed. And that's the challenge I see when I look at 12A, although if the object of 12A primarily stemmed from what Supreme Court thought that, this is a simple process, we should allow insolvency to close if there is a settlement between the corporate debtor and the creditor of the operational creditor or the financial creditor. That the court pre-2018 used the power under Article 142 and shut down certain cases to see that that the process can be closed and the company can work as a going concern. That's largely the objective prior to the amendment. But looking at the role, not only from 12A perspective, broadly from the entire perspective, starts from Section 14 stage, where such a massive responsibility is given to the resolution professional to run an entity or make an effort to run an entity as a going concern, and which is not an easy task. Which means the professional need to take the role of shareholder, need to take the role of the board, need to take the role of the engineer to see that the company is going on, and also to identify what are the services and goods which are essential for running the company, which means, let's say, a electricity connection disconnected, need to fight with the electricity board. And you would have seen that these kind of disputes have gone to the Supreme Court to see this position, that whether the RP is right or not right. So the width of knowledge and the width of the process which is to be taken by the resolution professional extremely wide and extremely critical. The second challenge which I see, which is again linked with 12A, is that RP cannot keep everybody happy. And the RP cannot keep everybody happy. The RP will be alleged to be siding on one side or the other. And you would have been aware that because of these kind of risks between the shareholders and the SRAs or COC members, there was an attempt to treat the RP as a public servant. And the consequence of treating it as a public servant means that you have Prevention of Corruption Act applies to him in spite of that there is a protection inbuilt in the act. Fortunately, Delhi High Court said that no, when we look at the function of RP, can't be. And that, to my understanding, is right. It's a commercial resolution based on a commercial expertise of a person that the process is being given. That's what my understanding is, that Delhi High Court is absolutely right on that. Now, the challenge comes with the 12A, if we look at which was a very simplistic objective of 2018 amendment, that we achieve closure and not affecting the right, because ultimately if the corporate debtor is finally settling with it, with the lenders or financial institutions, then there's the end of it, that why should the process be go on? That was the understanding. Supreme Court and consequently Parliament made amendment in the Act also. But I don't think the process has stopped there and then. The challenge starts from the day when somebody wants to settle, saying that we want to move in a settlement application, that I believe the life is easier if COC is not formed. Life is difficult once the COC is formed. And 12A interpretation, first of all, on the face of it is very clear that this is a provision which has been factoring in once the COC is formed, because the 90% will come into play only once the COC has been formed. Then only the question of 90% or more than 90% will come. Which means the pre-COC, whether this can be, the 12A can be used for settling or not. Again, the Supreme Court had to intervene in it, and Supreme Court finally said that 12A is going to give a rise to both kind of settlement, which is pre-COC and post-COC. That part has been cleared. But the difficulty is that once the application has been filed by anybody who wished to settle, the first port of call is the resolution professional. And therefore, the resolution professional needs to take a call whether this is an application which amounts to settlement and a fit settlement. And the challenge begins at that point in time, whether the settlement is coming from the promoter group, promoter entity, promoter related entity. And the counter allegation is going to start from the multiple parties, because there may be a small claim which takes Section 7 shape or Section 9 shape. At that stage, what do you do with the other claimants who are there? And multiple applications go to that. I believe that's where the role of the resolution professional is extremely critical, which is to be taken care of. There has to be the understanding of commerce and what is the position of the balance sheet from the accounting standpoint. And then based on that, the application filing responsibility also lies with the RP. And we have seen, I mean, at least since I don't go to NCLT, but I've been informed, there are numerous cases where although RP is considering the claim and file an application, at that stage, multiple intervention applications come to say that, to malign the RP, to say that they are taking siding on one side, they are not looking at the other claimants, and so on and so forth. But broad picture, I understand is, but the Supreme Court has also looked into it, that if it is pre-RP stage, then at that the application is filed. If the RP takes it to the NCLT, the NCLT is supposed to close it, because at that stage, the rights of other claimants are not affected. They can reinitiate the process. Post COC, what I fundamentally see is that the issue is application is to be taken to COC. COC need to apply mine. More than 90% of the participating COC members, voting members, need to confirm that yes, this is a case which is to be taken to that. At that stage also, it's not easy. The promoters always resist in one form or the other, or other COC members going to resist, and the multiple claimants going to resist. Now, to resolve this slugfest before the adjudicating authority itself is a challenge. And as I said, my understanding is that the RP is the first who can be attacked in these kind of proceedings. And knowing the position very well, that the RP is doing a professional job, RP is being engaged as a professional and paid resources or the fees out of the whatever the entire process is. If anything gets stuck at that stage, the sufferer is the RP. Although there has been allegations saying that the RP is unbiased, RP is favoritism, RP is corrupt, those kind of issues are there. What my understanding is, as I said, that the whole process cannot be driven unless the process is taken fairly, the process is taken through the process of law, and I would request if the others can just switch off their mic. I think that would help all of us. So broadly, what I see is that this challenge for RP is not going to end, and particularly in context to 12A, although it appears to be a well-meaning provision amended in 2018 to solve a problem that let the operating companies or going concern companies operate on their own, but the challenges for RPs remain, and I don't see this ending anytime soon. Although I can understand that at our level, when we go to Supreme Court, it's easy to make them understand, saying that the object of a provision of 12A is fine. But I believe by the time it reaches Supreme Court, the time and the allegation and counter allegations which go on the NCLT and NCLT stage, and the suffering which RP goes through is immense. But I don't know if there is any straight answer to it. But the fairness is the key in the process, and role of RP is extremely critical in taking a decision in terms of due process provided under the Act. That's broadly what I understand is. But at the same time, as I said earlier, the RPs broadly have done a fantastic job. They should appear and visibly be seen as an unbiased professional trying to resolve CIRP. And in the process, if there is allegation or counter allegation, I don't think they need to unnecessarily bothered by the process. They should take their job professionally and to the best of competence. And in the process, I wish all of you a great luck. And I can once again reaffirm that all of you have done a fantastic job. As a result, we are seeing closure to some largest of CIRPs in the country, including in some critical sectors like banking and financials, which is usually is not happening even in the West world, which is, I think, where these kind of resolution originated. So I wish you all the very best in the whole process and have a great seminar.
Thank you, sir. Thank you for your kind words. And it's nice to hear good things about IP from your good self. So thank you. Now I would request Dr. Ashish Makhija, sir, to express gratitude on behalf of IPNet and offer a memento to our chief guest. Ashish, sir. I think he is having some connectivity issues.
Okay, no, I'm there. Okay. So I think I was hearing very closely my friend Mr. Balbir saying, I think what he has spoken is absolutely correct. IPs have a tremendous role to play. They feel a lot of pressure, but at the end of the day, if you are doing everything right, I think there is nothing to be worried about. That's the message, the key takeaway. I think I can take it. Mr. Balbir Singh, I think on behalf of IPNet, I extend my heartfelt gratitude for gracing today's webinar with your presence and sharing your absolutely valuable insights. I think your words are deeply added great depth to the discussion. And of course, I believe there is a speaker, I think, who is going to take up this subject in greater detail. But we really, really appreciate your support and contribution to the insolvency profession also. You can see on screen, we are presenting this memento. So we request you to please accept it. This is virtual, but we will send you the hard copy very soon.
Well, thank you so much. I think I really appreciate it for having me. And I certainly see that all of you are extremely responsible and knowledgeable people. And as a result of which, I think I see from the western part of the world, the eastern part of the world, a lot of very, very complex IBC processes being resolved in the Supreme Court. And I certainly wish you all a great luck ahead.
Absolutely. Thank you, sir. Thank you so much for coming here. Thank you.
Thank you very much. Thank you.
Tina, you can proceed now.
Now I would request Mr. Vivek Chirania to introduce our lead speaker, IP Mr. Udayraj Patwardhan, sir.
I think before Mr. Chirania takes the stage, may I request all participants to please, if they can open their videos. I think this is, as I always say, we'd like to see smiling faces. This is not a faceless program. Thank you so much. I think this makes it more wonderful and more interactive. Thank you. Yes, Mr. Chirania, can you please go ahead?
Yeah, thank you, sir. So, Udayraj Patwardhan.
I think may I request everyone to please mute themselves because I think a lot of background noises are coming. Yeah, thank you. Yes, Mr. Chirania, please go ahead.
So, Udayraj Patwardhan is a seasoned chartered accountant and law graduate with over 28 years of professional experience. He is a founder partner of Messrs. Palnitkar and Patwardhan LLP, a medium-sized CA firm. He has been practicing as an insolvency professional since 2016, making him one of the early entrants in this field. Over the past 7 years, he has personally handled more than 48 assignments as a resolution professional and liquidator, and has advised on over 150 assignments, managing a debt resolution portfolio over rupees 25,000 crores. Mr. Patwardhan has addressed various professional gatherings of chartered accountants, company secretaries, advocates, bankers, and other stakeholders on topics related to the Insolvency and Bankruptcy Code, as well as finance, structuring, international finance, and corporate law. He has been trained by the World Bank as a master trainer for the Insolvency and Bankruptcy Code. Additionally, he serves as a visiting faculty at the Maharashtra Police Academy, lecturing on subjects such as the Prevention of Money Laundering Act, the Benami Properties Act, the importance of audit in cooperative societies, and frauds in the cooperative sector. According to the Insolvency and Bankruptcy Board of India, Mr. Patwardhan is a member of the Indian Institute of Insolvency Professionals of ICAI and is associated with Sumedha Management Solutions Private Limited. His extensive experience and active involvement in the insolvency professional has established him as a distinguished international speaker and a key contributor to the field. So I welcome Mr. Udayraj.
Thank you. Thank you for a generous introduction. I am from the family of IPNet, so I am not an outsider. I am an insider like you. And as we have been coordinating with guests for coming in and giving presentation, we thought that let us go back to our own team member before we go to our calendar of involving more and more speakers. So we will be having more speakers from outside soon, from maybe the next series that will start from next Saturday. So with that background, let us look at the two issues that we are looking at today. One issue is cooperation from the promoters, management, employees, etc. And second is provisions of Section 12A and withdrawal from out of the rigors of insolvency for the corporate debtor. Firstly, I would like to look at the non-cooperation part primarily for about 70% of the time, and then we will go to withdrawal under Section 12A read with Regulation 30A of the CIRP regulations. Please feel free to ask any question, any query at any point of time. Please chip in wherever you feel that something more has to be discussed on this, because I am only going to initiate discussions, read out the text of the law, and initiate discussions between all of us so that it becomes all collaborative discussion between all of us. With that, let me go back to the provisions. I will be referring to the text multiple times. So while we discuss our issues, we will of course be going to the book for multiple issues. So cooperation starts with the IRP coming into the place. When an order initiating the CIRP is issued by Honorable NCLT, the IRP is in the seat, and the IRP starts working towards resolution. And then in one of the duties of the IRP, it is important, I will bring your attention to only the relevant provisions. So I would draw your attention to two provisions under Section 18. One is Section 18A and Section 18F, which are very critical. Section 18A talks about duty of the IRP to collect all information relating to assets, finances, and operations of the CD for determining the financial position of the corporate debtor, including information relating to. Now you will ask me a question as to what is got to do with cooperation. Now this problem of the egg and the chicken was always there. And unless this information is made available to the IRP, how will IRP be able to work out these details which are required to be prepared in Section 18A, 1, 2, 3, and 4? What does it say in 18A1? Information about business operation for previous 2 years. Then financial and operational payments for previous 2 years. List of assets and liabilities as on initiation date and any other matter. So this information must be provided to the IRP by the management, by the personnel, and the suspended board of directors, the promoters, everybody who is related. So if they don't provide it, we can call it as non-cooperation. So that is the first point. Second point is 18F. The IRP has to take control and custody of any asset over which CD has ownership rights. What is next is important, as recorded in the balance sheet of the CD. So whatever is there in the balance sheet, the control and custody has to be taken. Or with IU or depository of securities or any other registry that records ownership of the assets. Including, then there are the assets which are given, assets for which ownership rights are there, which could be in foreign country, may or may not be in the possession of the CD, tangible assets, intangible assets. Now what used to happen is, initially when the code was launched, everything fell on the IRP to do this. He was expected to be Superman, doing everything, knowing everything without anybody telling him anything. If you would go to NCLT seeking that these details are not available,
વિની આપા કઈ ઇનપુટ ક્લેમ કરી હતી ઇન ટાઈમ ટ્રાન્સફર વીમા એને વે ચીજ થઈ હતી મને और वा મને આ પછે લાંદી લાસ્ટ માં એને વિનુ પહેલી મેં પછી મારે માતા બોડી કર વિનગન પાછી ફાઇલ બારે निकलवा चार्ज अगर गार्डन करी आ પછી मैं कि आप कदी अटेंड बारे वो सब हो वो मैं कर दियो जीते वो बटने ऑर्डर कर दियो विनु पहली वो वेट करियो ही कोनी विनु जीएसटी वाला रो वेट वाला रो
I request all those who are doing some other business while in the lecture to kindly mute themselves. So we were looking at 18F. So these duties are required to be done by the IRP. So for these duties to be performed, it is necessary that there has to be cooperation from the promoters and managers, etc., so that the information can be collected and can be presented in the IM for valuation for other purposes. So everything starts with cooperation for this critical information. Then we will also look at another section, section 17. Section 17.1. Section 17.2D is the subsection that I want you to look at. Section 17.2D would expect that the IRP would be able to seek information from anybody who has, and he will have access to the books of accounts, records, and other relevant documents of the CD available with government authorities, statutory auditors, accountants, and such other persons as may be required. So if you see section 18 and section 19, we many times miss out on section 17, management of affairs of CD by the IRP. So while the management vests with the IRP, the board powers are suspended, etc., and the officers and the managers of the CD will report to the interim resolution professional and provide access to documents as may be required. So even if we are looking at section 19 for cooperation, we cannot ignore section 17.1C, wherein the officers and managers are required to provide access to documents and records as are necessary. So this is another section which is important that we should be able to look at. And then I would draw your attention to 17.2D, that the IRP shall have authority to access books, records, documents of CD available with government authorities, statutory auditors, accountants, etc. So it is not necessary to run to Honorable NCLT on the first instance of non-availability of the books. These sections need to be referred to when we are asking for details, asking for documents, and then go to Honorable NCLT for whatever information that we seek from them. Now, this particular confusion as to what data to be sought, how much information to be sought, how to be sure that the information is being received, how to take control and custody of the assets, all these queries were very, very critical, and people were not getting any support for that. Then we also go to section 20 of duties of the RP, wherein it is necessary that the RP shall take immediate control and custody of the assets of the CD. There also we will need cooperation. So cooperation is needed in these many sections on the face of it. Section 17, section 18, and section 25. Now we go to section 19 for extending cooperation, which is very, very, very explicit that the personnel of the CD, its promoters, or any other person associated with the management of the CD. So you can see that there is repetitiveness. Section 17.1, section 17.2, section 18 all require that the information must be provided to the IRP and the RP. And section 19 is a very specific section which says that personnel to extend cooperation to the IRP and the personnel of the CD, its promoters, or any other person associated with the management. Any other persons means any other person. Employee, contractor, in charge, de facto in charge, paid, unpaid, whatever it is. That person who is associated with the management of the CD shall extend all assistance and cooperation to the IRP as may be required by him in managing the affairs of the CD. And then section 19.2 comes, where any personnel of the CD, its promoter, etc., which are required to assist and cooperate, does not assist or cooperate, then the IP make an application to AA, and subsection 3, the AA on receiving such application shall by order direct them to comply with the instructions of the RP and cooperate. So this is the general process that we have to follow. Now, if you ask me a question, how effective Section 19(2) has been, I will not be able to answer that it has been very effective against the non-cooperating promoters.
अपन फेवर में जाए कर अरे वह है हमारे लाइन में है, वह टेंशन मत करो। नहीं नहीं नहीं।
So it is not very effective, I would say, as we would expect it to be effective. So after noting that these are the issues that IRPs and RPs are having, and after getting feedback from Honorable NCLT had a feedback that IRP and the RP is not very particular about the details that are sought at the time of taking over the control, taking over the custody of the asset, and seeking data and information. The information is sought in generalized format. The handover is taken in an indefinite manner, in a very loose manner. The list of assets is not prepared properly, etc. Panchanama is not done. So all these were the observations. So from out of this, there has been a guidance, and that guidance comes from Regulation 3A of the CIRP regulations, which is a recent amendment that is amended recently, and we can have a look at that. We will take about 10-15 minutes to look at Regulation 3A. I would want all of us to go through it very carefully. It spells out as to how you take over custody. It spells out how you make the list of assets. It details as to what do you expect from the promoters while you are taking the custody, and then if that is not happening, then you are going to go to Honorable NCLT and seek for application to be filed under Section 19 subsection. Regulation 3A, sub-regulation 1. The IRP or RP, as the case may be, shall take custody and control as specified under this regulation from the personnel of the city, corporate its promoters, and other persons associated with the management of the CD, as the case may be. So they say that whatever has been stated in Section 17, Section 18, Section 25 will have to be done in the manner which we are specifying here in Regulation 3A. So A and B, records of information relating to assets, finances, operations of the CD referred to in Clause 18A. We saw Clause 18A when we started. Clause 18A talks about the information about the corporate debtor, his assets, his finances, operations for last 2 years, financial operational payments for last 2 years, list of assets and liabilities as an initiation date, and any other. So now the duty has been cast upon the promoters and the employees and the people who are in management and associated with the company to provide the information. So it is not only the duty of the IRP to make this information. He is collecting the information under Section 18, which is being provided by the promoters as per Regulation 3A. So this Regulation 3A did not exist earlier. It exists now, and you can see that this particular amendment is a 2023 amendment. It's a that way recent amendment. However, we see that many of the IRPs, RPs not necessarily follow this to the T. This must be followed in details. Then what information is required to be provided along with that? Information required under Regulation 36. That is information memorandum. So all the information which is required for information memorandum will also have to be provided by the people who are in charge, who have suspended management, promoters, other persons. So they will all have to provide their information on their own, under which is sought to be collected by the IRP under Section 18A, and for the purpose of Regulation 36 will have to be provided by the promoters. So we are going little beyond seeking and non-cooperation. There is an underlying duty which has been cast upon the management under Regulation 3A that they should provide this information to the IRP. So this is a very welcome amendment that is there in Regulation 3A. Now we go to 3A2. The personnel of the CD, its promoter, and any other person associated with the management of the CD. This is a common line which you will find in many of these paragraphs here. Shall provide the IRP or the RP a list of assets and records while handing over their custody and control, and the IRP and the RP, after taking such control, identify persons in whose possession these assets and records will lie. Two things. One, next duty is while the custody and the control is being handed over, list will be prepared by the company people only. That this is what I am handing over. So this is another duty that has been cast upon them, that the information will be prepared, collected, list made, and the list will be handed over to the IRP or the RP that this is the list, these are the issues, please identify, please verify, and take control. So again, this duty has been cast upon the management, and it is not expected that the IRP will go search and dabble around as to what is to be done. So the primary duty is of the management. Then after that is taken over or taken control of, another important provision under Regulation 3A, that the IRP or the RP can identify a person who could be an employee of the CD as well, whose possession these records will be held. So now the regulation is silent about it. I would interpret it like it can be in the possession of, say, a company secretary of the company can continue to hold in its possession the companies, the corporate, the seal of the company, the records of the corporate debtor, which are the seal or registers, FA register, etc., which are in the register office, can be continued to be held under the possession of, say, a company secretary. The cash may be entrusted to the cashier of the company. So now that formally it is possible to do that under Regulation 3A, Sub-Regulation 2. It is very much possible. Now a situation where such a list is not prepared and the IRP is required to go and take control. That is discussed in Sub-Regulation 3, where any asset or record has not been handed over or the list has not been prepared, then the IRP himself shall make a list. So then it is the duty of the IRP to make the list. So again, making list is mandatory as to what you are taking over. And while taking custody of the assets, and after taking such custody and control, again identify the persons in whose possession it will continue to remain. So two scenarios we have discussed. One is when it is handed over with a list. Second is not handed over or list not prepared. So in that case, IRP will do it. Now comes the point of Panchanama, which was never discussed at any point in the past. But many NCLT orders do refer to an issue of Panchanama. So that is Sub-Regulation 4. Each list of assets and records shall be signed by the parties present by at least two individuals who have witnessed the act of taking control and custody of such assets and records. So when Panchanama will be prepared, what we call it as Panchanama, this is not Panchanama as per the CRPC or IPC. So a record will be created that and so date, so and so person visited with so many people were present, all will be noted like we do it in the minutes of the meeting, who will present, who were available. And then a detailed list of assets will be there. And below that asset, including initials on each page, it will be stated that these assets have been taken over in this particular manner. So this is what is required. Now, why we are discussing this 3A in details is when we are seeking cooperation from the promoters, we should know what are we seeking, what are we going to do ourselves. If we don't know what we are going to do, how are we going to seek cooperation from them? It has to be very specific. Your action points have to be decided. that you will be going, you will be visiting on a particular date, you will be doing records, etc. So these regulations can be brought to the notice of the management that this is the process that we are going to follow for taking control, custody of the assets. And section 18A, section 18F, you have the obligation to provide me the details as per regulation 3A1. That has to be explained to them that this is the cooperation that is expected. It is written in the law. It is not something I am asking, or it is not my own prescription that I am asking. This is there in the law. It has to be given by you. You can't run away from this. Now we will go to sub-regulation 5. The IRP or the RP shall requisition from the personnel, again, personnel of the CD, promoter, any other person associated with the management of the CD, as the case may be, information relating to assets, etc., as per 18A, and information as per regulation 36, which were required to be maintained by the CD but not yet handed over. So 3A1 requires it should be handed over on its own. 2 says it is handed over with a list. 3 says list not prepared, not handed over. RP goes and takes it over. And then you do a Panchanama as per 4. In 5, they say that, however, after you compare the list and you look at what is required as per 18A and regulation 36, and if there are certain information details which has not been handed over, then RP, IRP shall have to write to the management that this is the information which is missing, which you have not handed over. Please hand it over to me. That is as per sub-regulation 5. So this is necessary that we should be going methodologically with a method and methodologically as per this regulation and sub-regulations. Then we go to sub-regulation 6. The IRP or the RP, as the case may be, shall requisition from its promoters the assets which are recorded in the balance sheet or any other records referred to in 18F whose custody has not been handed over. So any assets which have not been handed over, when we talk about 18F, that is the control and custody of the assets which we take over, and the record of the balance sheet and other registry will show you what are the assets of the company. If they are not handed over, then we will requisition those details from the management. So we cannot keep quiet that they were expected to do it, they did not do it. So 3A1, the duty is cast upon them. 18A, 18F, regulation 36, and everything over to you. 3A2, they hand it over to you with a list. 3A3, they hand it over, or don't hand it over with list or without list. Then the IRP will prepare the list, and in both 2 and 3, the possession can be given to certain employees or other persons in whose possession those assets can remain. Then we go to 4. 4 is about Panchanama. 5 is about requisitioning details which were not provided as per 18A and regulation 36. Then we go to 6, in which assets which are in the balance sheet, and in 18F not only handed over, requisition given, and then information is sought. Now we go to section 19.2, filing application of non-cooperation. Here they have reference in sub-regulation 7 that an application made under subsection 2 of section 19 in respect of failure to provide any assets and record as requisitioned under the code and this regulation shall show presence of such asset and record in the notice of requisition. So notice of requisition is very important. So you ask information, you compare information, you find out what is not available, you send a notice of requisition. Then in 19.2, you will show the notice of requisition that this is the notice which remains uncomplied. Then that application is going to be heard in a more effective way as per the current regulations. So shall show presence of such assets and record of in the notice of requisition and absence of such as asset or record in the list of assets or records taken into custody under 2 or 3. So even if you have taken it custody on your own, the asset is already with you. So will you be able to file 19.2? I'm not sure whether you will be able to file 19.2 or not. Because the asset which is not handed over, record which is not handed over, or which has not been taken by you, which remains absent, only for that 19.2 can be filed. Just because it took you more effort to take it over may not be a ground that they are not cooperating. When I go there, I don't find a promoter in the factory. I call them 3 times, then he comes, then he gives me 1 document, and back and 3, 4, 5 times every document is received. So that behavior, I don't think, unfortunately, we will be able to address as non-cooperation. So I will stop here for a minute. If you have anything to discuss, let us discuss for 5 minutes, and then we will proceed to some other provisions in Companies Act about taking control and custody, which I will want to bring to your notice. Anything that you all want to share at this stage about what we just discussed?
Sir, for how long we have to wait for them to respond? As you said that once he hand over 2 documents, next again he hand over another 3 documents, and now he is cooperating, but to an extent, and we are not getting the relevant documents. So for how long we have to wait?
Now, that is left to the IRP, but it has to be time bound. When we are talking about information which is required as per IM, you back calculate when you want to issue IM and accordingly set the timeline, and then go to NCLT under section 19 subsection 2. If you are not able to prepare IM in time because of this non-cooperation, an application will have to be filed. Because IBBI and IPA will ask you a question, there is a regulation in place, you are not able to prepare IM, why did you not go to NCLT? So my answer will be to save yourself from any possible action from IBBI or NCLT.
So
Practically, the IM may be delayed by 15 days and you may secure a very good resolution also. But to follow that particular regulation, one might be required to file an application under 92 by following this to the T. That is how the regulation is made. Regulation is made stepwise. There is no way out from that for us.
So you mean that we can give a timeline in the beginning itself, within 10 days or at the earliest you provide me, so that I proceed as per the timelines of CRP? Will that be better for us?
I would say that whenever the taking over is happening, the first letter that will go from the IRP will have to include most of these things, and also issue the also state the timelines as to when we want the information. The information should ideally be available to you on the first visit itself. Balance sheet for 2 years, business operation information for 2 years, bank statements, what is to be produced there, everything has to be available. What is the problem in that? But they don't give it to us. So we give additional 7 days time, additional 10 days time. That is another thing. But we never end up getting it. So I think 15 days time is max one can give, not beyond that. Because when you go to the COC, this is a recent regulation, only 2 years it has been. Not many COCs are asking questions about it. But soon COC will ask questions, show me your timetable that you have followed under regulation 3A. Once one guidance goes from ministry to bankers will start asking questions, make this one agenda, update of information secured under 3A, update to the COC. So let it be a point of discussion and point of noting in the COC meeting as well, in the first COC itself, that what has been the status. And if it is not too late, maybe this can be one of the agenda in the first COC meeting.
Books of accounts are not available when the IRP begins. So what course of action IP should take?
So this is the one thing that can be done under section 17 2D. Details can be sought from the auditors. But personally, my experience has been not all auditors are asked cooperative. They say, I don't have any data. My working notes I will not share. I don't have trial balance, or I don't have balance sheet copy. I have listened to such answers also. What to do? But in some cases, auditors are cooperative. They do share data, backup, tally, etc. Some forensic recovery is possible in many cases. So if that is possible, you can do that. But what happens, unfortunately, is when this IRP is initiated under section 7 or 9, let aside 10. 10 में तो IRP is suggested mostly by the promoters only. But in section 7 and section 9, the case goes on for a year. And you will find that the office of the corporate debtor is very clean with only 1 year balance sheet in place, new hard disk, new computer, or nothing there. So you know that this is not correct, but we don't have anything else but to go to NCLT under 19.2 for that.
But the IP is supposed to draw the balance sheet based on whatever data is available, or he could trace out, or
so that for that again, that is a typical view that is taken by the management. But if you look at by the NCLTs, but look at regulation 3A, it is their duty to provide you these details for 2 years. So you will have to seek from them first. This was not the provision earlier, but that is the provision now. So they are duty bound to provide it to you. If they deny to do it on affidavit for whatever reasons before NCLT, then of course you can go ahead and do it. Previously, what used to happen is NCLT honorable benches used to ask the IP, can you not do it on your own? Why are you asking this poor person to do it? That is how they used to look at the promoters. And I have seen that happening many times. I see many of us faces in NCLT Mumbai whenever I go. I see Arunji, I see Raviji there. We see such cases time and again. Promoters come there, they make a poor face, a baby face, and they get away with whatever they are doing. So let us not talk about it much.
Sir, generally the section 19.2 application orders are disposed of with directions, right?
Yes, they are disposed of with directions, but after this regulation, let me tell you, in one of my matter in Ahmedabad, when we followed this particular structure, the promoters were asked to put everything on affidavit as to what was handed over, when it was handed over, date of handover, mode of handover, and when they started making affidavit, actually 90% of the data was actually handed over to us because that promoter could not make an affidavit like that. So 3A helps, believe me. When you ask pointed information of 10, 15, 20, 30 items, that is handed over to you. And those who are seasoned, what I can say, culprits will not hand your information. We have seen people coming and telling that for last 4 years, we have not maintained books of accounts. Whatever is the penalty under the Companies Act, we will pay, make our complaint to Honorable ROC and start investigating against us. That is the answer also I have listened in one of the matters. So we see all types of people. And Honorable NCLT also said that he has not maintained the books. What will he do? He cannot give you anything.
Sir, in the process of this handing over, taking over, and there is some kind of issues between the management and these people will be getting threat calls from them also, or from the outsiders related to them. And we approach some police authorities. If we are not getting a cooperation from them, from police authorities, can we go under this section 19?
I will come to that in 2 minutes. There is one more section under Companies Act which mandates NCLT to provide police protection to the IRP under IBC. I have used that multiple times and successfully. So I will share that with you all also. But before that, any inputs from 19.2? I see many seniors here who are having as good or more experience than me. So any inputs from 19.2? Because I am not satisfied with performance of 19.2. So that is my my input. So when there is no cooperation, there is no cooperation, and when there is cooperation, they do all the cooperation. So that is how.
Any questions? Any inputs? Yes, sir. Ravi, sir.
Ravi sir, आपको मुंह से बस आ नहीं रहा है बात करिए.
19.2 unfortunately does not specify any penalty anywhere at all, except when you go under the general provisions of IBC. So it is assumed to be directory by everybody concerned, except the RP. It's mandatory for the RP directory for everyone else. So I think you have been putting it very mildly. 19.2 has been an unmitigated disaster. And
I
unless
second, sir.
something is done in a way where it's tied up with some other provision, which will invite some sort of penalty, then it will be looked at as, okay, oh, now it is mandatory. Let's do something about it. So it's not there directly, but some linkage has to be tied up with something.
Yes. So with what Raviji is suggesting, I would draw attention of everybody to provisions of section 70, which is punishment for misconduct in the course of CIRP. We have tried to invoke this section in 19.2, but we have not been successful. Section 70 is punishment for misconduct in the course of CIRP, which says that on or after the commencement date, where officer of the CD, then there are 3-4 points. Look at B. Does not deliver to the RP all or part of the property of the CD in his control or custody when he is required to deliver. Does not deliver to the RP all the books and papers in his control or custody belonging to the CD which he is required to deliver. So there are provisions, but when we have tried to do that, we have not been successful. NCLTs keep their hands away from these penal provisions. I am aware of only one case of Calcutta wherein 2 lakh rupee penalty has been charged. That was in 2018 or 19 somewhere. Thereafter, no. So that is one thing that I know.
Sir, there is a question for you in the chat
if I
box.
may just supplementary, just one second. In this section 70, the keywords are in his control or custody.
In whose control?
Oh, straight बोलता है मेरे पास है नहीं. खत्म. The whole provision goes for a toss because of that, which ought to be in his control or custody. If the wording is changed, straight away it will change. And it says officer of the CD. Unfortunately, that section does not say director promoter.
Because 3A talks about any person connected with management. And here it is officer of the CD. So officer might be a KMP, and that KMP may or may not be agreeing that it is under my control and custody.
Mostly they will say, I never had it. There was somebody XYZ who left about 3 days ago, 3 months ago, or 3 years ago, whatever they feel like. And that's it. It's gone with the wind.
True. Sir, there is a question for you. Patwardhan sir, unit was running on the land and building belongs to individuals, and there is no agreement in record to show that the CD has a right to conduct the business in the factory building, as it is incidentally belonging to individuals. How to deal with it?
Ask the creditor who gave loan for such a asset. That creditor will be better positioned to answer. You may find some kind of an agreement, some kind of an understanding between the promoter, that is the landowner, and the factory owner company or the LLP, which could be there. Now, when we are discussing this, please note that the creditor who has this information with him has to cooperate with the IRP and provide all the information. So that is another amendment which has been done in the code, that the creditor who has information with him will have to provide all the information, including stock audit reports, everything which they have with them, to the IRP, in which such an arrangement will be there. I don't believe that a banker will give a loan for such an weird kind of an arrangement without some kind of a consent from the land. So some type of consent will be there, good or bad. So some document would be there. Whether that is enough, whether it was correct commercial wisdom or not, that is another thing. Or whether there was some delinquency on the part of the creditor, I'm not going into that. But some connecting document would be there, which we can find out. And if not, then I don't see any solution here.
Yes, sir. Thank you, sir. Thank you. Thank you. Sir, you can. Arun, sir, you can. Yes.
Udaji, इस matter में what has happened, that the land owner is one of the borrowers. So the land has been mortgaged to the FC, and subsequently the facility which is given is PC.
So then IRP will have to be come out with some innovative solution of disposing of both assets simultaneously. Some engineering ways will have to be there to get out of this place, because sometimes it can be legally perfectly all right, but still there is no solution. Like we do in insurance.
सॉल्यूशन एक हो सकता है कि आप जब RFR फॉर्म जी करें, prior to that you take a consent of FC that RP can sell the or call resolution plan for mortgage property also.
Yeah, so that can be conducted simultaneously also, like we do it in procedural insolvency, wherein all the companies are independent of each other. However, Form G is issued simultaneously, and people are encouraged to give a resolution for all together. Such kind of an arrangement will have to be done. I don't see a legal solution for this.
Okay, thank you.
There is one legal solution which is adopted or used to be adopted during CDR days, and that's called pooling of security, which means where the creditor holding the mortgage interest or a security interest actually gives a letter to the RP. I am pulling my security into this pool, which is part of this ARP pool. So please go ahead and include it. So that establishes the legality of including it.
So we will come back to this point again. I will now take you to a section out of Companies Act, which we have been successfully used for taking custody of assets by police help. I will take you to section 429 of the Companies Act. If you have access to computer, please type out section 429. We will read it together. It's a very fantastic, very helpful, and I have been able to seek help from police commissioner and get an order from another NCLT. When we showed it to them, they did not know what to do about it, but they gave me an order.
Sir, can you share the screen? It will be good for everyone.
That is on another computer, actually. I am speaking from another computer. I am speaking from my tab, and that is on my computer. But you type section 429 of Companies Act on your phone also, it will come in a second. So I will read it for everybody now. Power to seek assistance of CMM, etc. CMM is Chief Metropolitan Magistrate, which is in a metropolitan area. Otherwise, we will go to Police Commissioner also. 1. The tribunal may, in any proceedings for winding up, yes, that is there. The tribunal may, in any proceeding for winding up of a company under this act, or this is an amendment done for IBC, which we have missed earlier. But in some search that I was doing, I could locate that. In any proceeding under the IBC, in order to take custody or under its control, all property, books of account, or other document, request in writing, the CMM, the CJM, or the district collector within whose jurisdiction such property, books of account, etc., is said code are situated or found, take possession thereof, and the CMM, etc., maybe shall on such request being made to him, 1, take possession of such property, books of account, cause the same to be entrusted to the tribunal or other person entrusted. 2, for the purpose of seeking compliance under this code, the CMM, etc., shall take as such steps, use force in his opinion as necessary. 3rd is very important. No act of the CMM, CJM, or DC done in pursuance with section shall be called in question in any court before any authority on any ground whatsoever. Very powerful section. So please remember to use it whenever you want to use it, when you want to take custody, and when there is resistance for custody. In one of the case I was doing in Pune, I had fierce resistance, including stone pelting, etc., was threatened to me across the board, and they told me that these are the people which are standing there, which are going to come and hit you and break your arm and leg also. I did not face those issues when I went to Orissa and when I went to interior of Karnataka. But I had this within the jurisdiction of Pune Municipal Corporation in Pune. I faced this. So we went to Honorable NCLT. We referred to this section 19.2 and section 429, and we got a good order directing the police commissioner to provide me police protection, which we did. We paid the necessary fees for police protection, because police protection doesn't come for free, even if there is an order. Say if there is an order, then we will go. He asked me how much police protection you needed. I said I need 3 police male, 1 police female, 1 constable. So he allotted that. I paid the fee. They came with me and I took custody. So it took me about a month. But let me tell you that this section 429, in case of non-cooperation for custody and not being handed over, if you want to use it, you can do it. You can always start from the local police station, but you can't show the police station section 429, because if you show them 429, they will say go to court and take an order. So we don't want it a regular thing, because if you show them 429, say okay, barabar likha hai, go to NCLT, get an order, I will help you. We don't want that. So seek a help from them whenever necessary. If they don't give you the help, then you go to NCLT with 19.2, seek help, and then you will be successful in that. So that is my submission here.
So in the letter we can mention the section inviting their attention.
Sir, I don't do that. I just expect them that they are obliged to help us and all that. But I don't mention 429 when I am writing a letter to the police station. Whenever we go for taking over the custody, we do write a letter to the local police station, meet the police officer, tell them that we are going to do this. Now they are also mostly aware of what IBC is and who we are and what we do. So they do help. It is not that they don't help. But in some cases, the promoter themselves create some issues, and in such case, this is helpful. But these issues were very, very strong in 17, 18, 19. But nowadays, I don't see much of these issues coming forward to trouble the IP in taking custody or taking possession. It is mostly okay now. Yes, Ravi ji, kuch bol rahe the aap.
2 points. Section 30 of IBC seems to be a sort of a mirror of 429.
Yes, it is.
Sort of. I mean, though it's not that elaborate, but it does cover the substantive portion of that. But there is one thing missing. In the entire IBC or even in Companies Act, you can't go to police directly. You are supposed to go through the district administration or that. Yes. So that has come up. Some knowledgeable police people have said, no, you can't come to me directly.
They say that. If you meet typically a DCP or a CP, he knows what the law is.
Yes.
So he smiles, he will give a cup of tea with two high-end biscuits and send you back.
Yes. So maybe going to the district administration route is probably better.
Yes.
Yeah. But that, of course, involves more time.
Yes, it involves time. So getting a good order from NCLT is also difficult.
Yes, Deepak ji, you have any question? Yes, Uday ji, proceed.
Yes. Now we will go to the other part that we wanted to discuss, is the TVLA Regulation 30A and the present status of TVLA. Section 12A was the provision, and we are all aware that this provision came later into the law, and the withdrawal was allowed. We always go back to Swiss ribbons for the requirement or why government needed to do this, so that there is a possibility of settlement between the promoters or any other person and the financial creditor who has filed the application, or the operational creditor who has filed the application, so that one can get out. We can start our debate at the first point as to whether it is necessary that it's only the promoters or the ex-promoters or the ex-directors who shall propose a settlement. I have a view that anybody can go and propose a settlement, They can have any back-end deal with the promoters or whatever they want to do with the company. The applicant will have to satisfy itself that he is satisfied of whatever he wants to do with his claim. Now, there is always a question that if IBC is a resolution mechanism, how come somebody recovers money and goes away? So that is another question which also comes up. So we can discuss those at length or at superficial level, whatever we want, because though we talk about resolution all the time. Mr. Arvind Saxena, आपका phone mute कर दीजिए. It has been 4th or 5th time that we are listening to your private talk with somebody. Yes. So it is though IBC is considered to be a non-recovery mechanism, still everybody looks at it as a recovery mechanism only. Even the resolutions that we see, most of the resolutions are recovery type resolutions. We are all aware of that. So this is something like an elephant in the room, which nobody wants to talk. We also need not talk. But if we want to talk about it, fine, we can do that for some time. But now about 12A and 30A. I have been instrumental in more than 15 withdrawals of under section 12A in my own cases, let aside other cases. So 12A has been successful. Out of these 12, 13, 14 cases, 10 cases were settled by a resolution applicant in a group insolvency company. So the resolution applicant had submitted a resolution plan for holding company approved by the COC, and then because the land was, it was a real estate company and the land was held in subsidiary companies. So RA went and satisfied the single COC member who was 100%, and there was a settlement between them, and he gave me form FA, I submitted, NCLT allowed. Whether it is proper or not, I am not going to be able to comment on that. Did I have an agreement of settlement? I did not have an agreement of settlement also. It was only form FA that was given to me. I submitted to NCLT. It was allowed as withdrawn, and reputed law firms were involved. Nobody questioned anything. Neither the bench questioned anything. So it happened. Is it proper? I don't know. Today, when we are talking about withdrawal under section 12A, we are talking about withdrawal of under section 12A post the case of Baiju's case in Supreme Court. So everything has changed. What used to happen in between is everybody had forgotten 12A and everybody had forgotten 30A. What used to happen is there would be an admission under section 7 or section 9. The promoter would run in 3 days, 4 days, 5 days to Honorable NCLAT, offer to pay something upfront, get a stay on formation of the COC, offer some amount there as a settlement. The settlement would continue to happen between parties for 1 month, 2 months, 3 months, in some cases even 7-8 months also. And when it was settled, the Honorable NCLT would say that now the matter is settled between the parties. So the section 7 or section 9 is now set aside. So this was something which was going on for almost a year. And in one of the cases, I have been hit personally because my CRP cost has not been paid. Bench said, I am setting aside this case, Honorable NCLT said, and for your fees, you go to NCLT. So I filed an application in NCLT saying that settlement has happened there, but my fees are not paid because 12A is not followed. Please pay me my fees. So that is still going on. 2 years have passed. I have not got my fee yet.
Can you please remove this gentleman? He is a serial offender.
I don't know whether I can mute them or not. I am doing it on my tab, so I don't know the controls.
I think who is the host, they can do that.
I am also administrator, but I am not able to mute that. Anyway, chalo. If it comes back again, we will see.
I think, sir, the team has already done it. So we'll watch it, and in case it pops up again, then we will remove that person. So don't worry.
Fine, sir. Fine. So this used to happen. So now what has happened is we will look at the 4 important paragraphs in Baiju's order. What I will do is I will log in from my other gadget also simultaneously, so that I can display it on the screen because they are very critical.
Yes, Mr. Patwardhan, I think it's important that we should discuss that Baiju's case because that's a
Yes,
very, it's
yes,
setting a landmark precedent in this particular area.
yes, yes.
Online बात थोड़ा बता.
Again, see,
Mr. Harvinder, can we request you to please keep yourself muted? I think we have been facing this issue. Thank you.
So I'm logging out for this gadget. I will log in from my another gadget, please.
you want somebody else to share the order? That way it will be easier for you.
Yes, that can be
I
done. If
can
that
do
can be
it
done.
if
Ah,
you
yes,
want.
please do it. Yeah, please do it. And go to para 63 directly.
Order dated
Order dated. Okay. You can just
23rd October 2024. Supreme Court. It will be under glass trust judgment.
Sir, you can continue while it is being shared.
Yes, yes.
So
I will continue. Yes, sir. I will start with para 63 directly. So I think we should have it on the screen. I will also log in. I am sharing that link.
if you could share with me on WhatsApp because I'm also using another laptop of mine.
Yeah, don't worry. I have logged in now and I will be able to share.
Yeah, if you share with me on WhatsApp, I will be sharing.
हो गया. I have logged in. Yes. So now we are looking at this is a very critical order which has been passed while our previous Chief Justice was in his seat. And let us read this para 63 very carefully, especially sub point 2. So we will start. In essence, after a series of deliberations by the legislature, the executive and the nudges by this court, the framework created by Rule 8 of NCLT rules and Section 12A read with 30A lays down an exhaustive procedure for withdrawal of an application filed by creditors under Section 7, 9 or 10 of the IBC. Now, 10 shouldn't have been here, but still it is there. Withdrawal may be sought at 4 stages, all of which have a procedure prescribed under the framework. That is now summarized here, and that is what I would say is the law that they have stated. First is before the application is admitted. So there is no question, they can settle it on their own. There is no question about it. What we are looking at is a position under 2. An application under Section 7, 9 and 10 is admitted, but before COC has been constituted. Although Section 12A continues to be silent on this aspect, after the decision in Swiss Ribbons, Regulation 30A was amended to provide this eventuality. What eventuality? Eventuality of settlement and withdrawal before constitution of Committee of Creditors. That is before 23rd day of insolvency, because COC is required to be formed by 23rd day. 14 days for the announcement, 7 days for verification, list of creditors ready on 21st day. You have 2 days to file that with NCLT, so 23rd day. So it was amended to provide for this eventuality. An application for withdrawal in such cases may be made by an application through the IRP. The IRP will then place this application before NCLT, which may pass an order either approving or rejecting the application. So no problem up to this point. As noted above, once application has been admitted, read this carefully. the proceedings are no longer the sole preserve of the applicant, creditor, and the CD. They are now in REM, and at this stage, NCLT must hear the concerned parties and consider all relevant factors before approving or rejecting the application for withdrawal. So even if we are in the stage before the COC is formed, this is what Honorable Supreme Court has commented upon and passed an order accordingly, that the proceedings are no longer the sole preserve of the applicant, creditor, and the CD. They are now in REM, and at this stage, NCLT must hear the concerned parties and consider all relevant factors before approving or rejecting the application for withdrawal. So this is an important change which has been by way of an interpretation of this order, that NCLT, they say, being a quasi-judicial body, must not act as a mere post office, which stamps and approves every settlement agreement without application of judicial mind. So this is an important change which has been brought about because of this order in the matter of in the matter of Glass versus Byju's, and this is something which is now getting into the process. Whenever somebody goes and tries to file an Section 12A application, those creditors who have submitted their claim do come up before NCLT and say that even if the COC is not formed, when the COC is formed, 90% approval is required. We all know that. Even in case of a housing project where class of creditors are involved, even in their case, 90% is required. When the class of creditors will be counted individually and not as a group, where a decision is taken by 51%. In 12A, that is not allowed. That is an exception. That in 12A, all creditors will individually be counted, and if COC is formed, 90% plus will be taken into consideration to allow or not allow a withdrawal under 12A. So now, before COC also, Honorable NCLT will listen to the objections and decide whether they will allow such a withdrawal or not. So following this particular resolution, two recent judgments have come to my notice. One is judgment in the matter of Himanshu Singh versus HDFC Bank. This was pronounced about a month ago by NCLT. I will share that with you all on the group. And the other one is of Bench 2 of Mumbai in the matter of Seska LED Lights Private Limited. In both cases, 12A application filed before formation of COC was rejected on the grounds that the other creditors had serious objection about proceeding with 12A, saying that one point was there was no provision with the company to settle other creditors. No plans were approved by them. They were not sure about its continuity. They said that my claims are there. They must be answered as to how they are going to be settled and how the company will be continued. And if we are not paid, there will be multiplicity of hearing. So why are you settling this? Let it continue. So all these arguments were made, and the cases were rejected in two cases, as I have said recently, one by NCLT Mumbai and one by NCLT in both cases. So I will pause at this point. I don't have to discuss 12A and 30A with you. You all are aware of the process. So now we can discuss this point in more details by interactions, and anything more needed, I can dig into this order into more details, because this order discusses many other issues other than this summary that they have taken out, which is purely on law.
Any questions?
Sir, what will be the IRP position in that case?
The IRP will continue till the 12A is decided.
Sir,
Then when 12A is decided.
So
listen, I have not completed my answers.
Okay.
IRP will continue till 12A is decided. When 12A is decided, when withdrawal is done, IRP will be a functus officio. If 12A is rejected, then IRP will continue to work as an IRP and CRP will continue.
No, sir, my question is, what will be the IRP? Because now the creditors who have submitted the claims can object to a 12-year application. Whether IRP has to do anything regarding that?
No, the objections will be coming before NCLT in the 12A application. Now the 12A application typically doesn't have any respondents. So nobody will be able to file a reply in that application. So they will have to file intervening applications in the application filed by the IRP. All those applications will be heard and then the decision will be made in the application filed by the IRP.
Thank you, sir.
Sir, sometimes 12A takes so much of time that the resolution plans are also there. And if such situation happens that the plan gets approved and 12A doesn't get decided.
No, I may not agree with this situation in a way that when 12A application is filed in the resolution stage or something like that, then 90+% creditors have already approved that 12A. So in such case, one can always go and seek the kind of a relief from the court that till 12A is decided, the resolution plan may not be acted upon or may not be heard. So that is possible.
I think this sort of issue was sort of decided that when there is a plan which has been approved by COC, they are not allowed to consider a 12A. They're not supposed to.
No, they're not
They can
supposed
do
to
it.
agree.
And it was with extreme reluctance and as a special circumstance that in Shiva Industries, Supreme Court allowed it because the plan had failed. That was rejected. So when there is an accepted plan, the concept of 12A does not exist till the plan gets rejected. 12A can come back after the plan is rejected either by COC or by NCLT.
Plan is rejected
or they are binary. There is 0-1, either this or that. It can't be both.
Either plan is rejected or the resolution applicant expresses inability to implement. I have seen that also happening.
Yeah, which will follow IBIX in another way. But the question there would arise: will IBIX prevail before 12A?
IBIX will prevail in that case. His deposit will be forfeited, and sometimes somehow people manage such things that deposit is allowed to be forfeited, and still 12A happens.
Sir, when the company is under control of IRP, the promoters can make any settlement proposal to the applicant that way.
They do. It is possible for them to do a settlement agreement with outsiders on the basis of their own resources. So they can do that. Sometimes we have seen that some third-party investor comes in and they entered into kind of an MOU, wherein after the investor agrees to settle the creditors, and then the 12A is withdrawn. However, in such a scenario, the money is generally kept in an escrow account or a null account.
The company sources will not be used for that settlement.
They cannot be used. They cannot.
Actually, if you go very technically, the word settlement is not used anywhere.
No, it is not.
It is not in the code. It is not in the regulation. It does not even require a settlement. It's just that people have to agree for whatever be the consideration. And I have seen 12A, which on the back-to-back agreements which they make, does involve repayment over a period of time from the cash flows of the company. It's like a restructuring.
It happens.
It can happen as long as 90% people say. That's why the threshold. See, the assumption is that at 90%, more or less everything is taken care of. And another thing, most important, nothing gets extinguished in 12A. Every single due of tax, etc., gets revived in 100%. And all their powers to recover will be there. So,
sir, one more thing. If it is withdrawn, right?
Yes.
Once it is withdrawn, now the IRP was holding for a particular period. Then who will sign the balance sheet?
The balance sheet is typically signed by the IRP and the directors who are suspended. There is nothing that stops them from signing on the instructions of the IRP.
It is withdrawn in, you may say, before that October date, right? It is withdrawn in somewhere
It will be
August.
signed by
When?
the person who will be on the seat when the balance sheets are signed.
Yes.
If this whole process is withdrawn, say by July, and the
Hmm.
balance sheet is signed in September, so the person who is director in September will sign. A person who is functus officio is not going to come back from past and sign the balance sheet. That will not happen. I have received request, like you have said, that this is your period balance sheet, please sign
Yes,
it.
yes, me too. That's
So that
why
happens.
they know the duties of RP.
They know everything about you. They don't know their own duties.
Any other question from anyone? No questions, sir. You may proceed.
Ashish ji, your views on this present issue
Yeah.
of delay and 30A, because
Okay.
actually those pre-COC settlements are simply not happening because of this. And everybody is worried about what is going to happen. We are expecting that this matter of Bombay and at NCLT Delhi in case of Himanshu Singh HDFC will reach Supreme Court and something will be decided this way or that way. But we are still wondering that pre-COC thing is no longer something which is possible.
Okay. See,
If I may,
sorry. Sorry. No, go ahead. Go ahead, Mr. Gandhi.
Yeah, the pre-COC is not provided in the law. It is inserted by a judgment of the Supreme Court. If you go back, you'll find that it was never envisaged. The ILC never wanted it to be pre-COC. They deliberated and said it has to be, COC has to be formed. It shall be after 90. Rule 11 shall not be used. It's there, all. It, and the Supreme Court is quoting it in glass judgment itself. But it was that there was this period of beech mein karna hai. Then Supreme Court in that judgment said, Rule 11, NCLT can go, you can directly approach. Now, having said that once, they are going to withdraw it in incremental steps over a period of time. Byju's is one step towards that. Soon, maybe sooner later than later, pre-COC will go away. It's not supposed to be there.
Okay, so having said that, in fact, Mr. Gandhi is right. Initially, when the withdrawal provisions were not there, particularly Section 12A, of course, Regulation 30A came much later. But at that time, Supreme Court was using its powers under Article 142 to allow withdrawals. We have seen a flurry of cases in the beginning. I think almost around 8 to 10 cases happened. But ultimately, in one of the judgments, Supreme Court wrote that we request the ministry, the central government, to insert provisions relating to withdrawal. Now, when the committee considered that, naturally they have to follow what the Honorable Supreme Court says, but they were not in a mood because, in fact, they quoted BLRC had said, where is the question of, withdrawal? The CIRP is a process which is trying to resolve the insolvency. So where is the question of withdrawal at this stage? But having said that, since the Supreme Court had directed in a subtle manner, so they typically, what they did, they wanted to make the provision very, very difficult. So therefore, you can see that it is like a super majority of 90%. It's not like 66%. So they said, no, typically a whole body of COC should approve for withdrawal. So there was no concept of, withdrawal prior to COC. So they simply brought in a provision that COC must be constituted and 90% of the COC must do this. So this was the objective. But somehow or the other, when IBBI framed those regulations, they diluted the provision and they brought a new concept of before the formation of the COC, which was not the intent under 12A, typically speaking. But anyway, let's look at few of the judgments. I will just quote, maybe somebody can write it on the chat box. One is Brilliant Alloys versus S. Rajgopal. Now, that is a judgment of Supreme Court in 2019. Now, it clearly says that Regulation 30A is not mandatory but directory. So this is what they are saying. And the application can still be made before plan approval. So one aspect is prior to constitution of COC. The second stage is till what time this application should be made. So in fact, the Supreme Court permitted that this could be made even before the plan approval. It can still be made before plan approval. Now, some applications are coming even after the plan approval also. But in that case, I think there is an enclad judgment of Hero FinCorp, where they say that once the resolution plan is approved and awaiting NCLT approval, allowing 12A withdrawal would undermine the process. So this is also of 2019 Hero FinCorp, but it is of NCLAT. And similarly, in Coal India versus Gulf Oil Lubricants India Limited, again NCLAT held that you see 12A has to be rejected, holding that the process cannot be derailed at such a late stage. So once the plan has been approved or is pending for approval before the COC, typically they say the stage is very, very late. And in Ashok G. Rajani's case, versus Beacon Trusteeship, again NCLAT has held that once the withdrawal cannot be permitted merely at the whims of the promoter once the process reaches the advanced stage. So I think we have got few judgments of NCLAT typically saying that at a later stage, it should not be done. But yes, in many cases, NCLT and NCLAT have been very liberal, and they have been permitting promoters to come and withdraw also, which is actually not the intent of the law. So I would definitely like to see more Supreme Court judgments on this rather than going on NCLT, because NCLT judgments are, I mean, well, they are courts, we have to respect them, but at the end of the day, there are a lot of contradictions, there are a lot of inconsistency between various benches also. So that is what is the need of the hour. Okay, friends, I think.
To add to what you're saying, sir,
Yeah.
there is a Supreme Court judgment, Abhishek versus Huhtamaki PPL, where Supreme Court judgment has clearly said that the AA was mistaken in his order of rejecting a withdrawal application under Section 30A. And he has clearly said that this order stating that Section 12A prohibits withdrawal prior to formation of COC cannot be ordered because Regulation 30A specifically permits the withdrawal prior to formation of COC. So, and in this judgment, the Supreme Court has further quoted Swiss Ribbons versus Union of India to say that yes, there can be applications for withdrawal prior to formation of COC. So there is a Supreme Court judgment apart from the NCLAT judgments that you have already quoted.
That is excellent argument. Right. You know, first Supreme Court says you must allow, then a regulation comes, then they say, now there is a regulation you must allow. That's what happened. Exactly what happened. The Supreme Court first said you must allow, then the regulation got amended. 30A in its current form is an amended portion which allowed withdrawal before constitution of COC subsequent to a Supreme Court observation.
True. I think these are few judgments which have already been put on your chat box. Friends, I think you can just download them, note it down, take a photo so that you can read these very, very important judgments on the withdrawal relating to 12A. So I think we had a great discussion on when Mr. Patwardhan led that discussion today. And of course, the chief guest set the tone. Friends, if you still have any questions, I think we can deal with that. Tina, can you just take it over from here?
Yes, sir. There is a question in the chat box. If 12A is filed before COC constitution, what happens to other claimants? Because settlement happens between FC and applicant, but I think it was already addressed. Sir? Sir, you are on mute.
What we discussed and what Mr. Ravi also stated, that if the settlement happens, then the settled creditor will go away. However, the other creditors, other claims, everything will go back to its original position, and they will be able to continue with their position as a creditor and continue doing business, or if they are already in default, then proceed with any recovery that they may want to. So the settlement will be only with the creditor which has agreed to that settlement. However, as also pointed out, for 12A, settlement is not a prerequisite. 12A can happen without settlement also. So settlement, we are considering that creditor will agree only if there is a settlement, but that is not mandatory.
Okay. That means that without, they can have terms agreed between themselves that within so and so years he will pay, and then also they can come with a 12A withdrawal, right?
These terms of settlement or so-called consent terms, which became a practice in NCLT, is actually not mandated by law and not even desirable, actually.
Okay.
Because it's supposed to be, 12A is supposed to be simpliciter withdrawal. Okay, you got, okay, go. No right to reinstate, restore, all that which is happening, which is actually messing up the objective of law. But in terms of the question that was asked as to what happens to 12A one thing, now the NCLT Court 2 judgment in Cisca LED will probably be the standard where everybody else will follow that. They will start issuing notices to other creditors to place their objections, if any.
Sir, if 98% creditor agree and 2% place an objection, it will prolong the process.
90% COC, there is nothing, no such other additional thing that will happen. Because that is following the original intent of law. We are talking of before COC, when all
before
this
COC.
Once COC is formed, there is no issue. It has to be 90%. There is no midway there. Thoda adjust kar lenge nahi chalta hai.
Sir, with all the settlement means this 12A withdrawal application, we have to submit the settlement agreement also along with that. What has happened between the FC and
Law doesn't
applicant?
require it, but practice does.
Practice does. No, sir, we have to submit, though it is an internal document between both the parties.
When you prepare that application for withdrawal, when you refer to a settlement, immediately it is your duty bound to attach that and bring it before the notice of the bench. Otherwise, you can't refer to it only in your application and not submit it with the application. So you refer to an settlement, in the application it will have to be provided.
One more thing is there is a DD in the name of the company to be drawn at the time of settlement. So how RP will encash that DD?
How will money come to the company?
No,
that is mentioned,
a
sir. That is
drafting error
mentioned.
in the regulation.
No,
Please
correct.
read it as in favor of RP. Okay.
Yes. That's what,
No,
sir.
that you're saying. I will tell you what happens practically. Practically, sometimes the money is paid in advance, sometimes an undertaking is given, sometimes an affidavit is given, sometimes an DG is given, sometimes even a check is given. All NCLTs have accepted in the past. But that is past.
Yes.
That is past. And after this money is paid, RPs have run after the settlers for payment of balance fee also. When they pay this is as of date of filing of 12A. Thereafter 4 months are gone, RP runs after everybody for their fees. After settlement order is received. So that also I have seen.
Sir, I have a question. I was appointed as an IRP for one of the running company, which is an active company, and there were immediately after admission of the company to the CD, there was a settlement between one of the operational creditor who has filed the application. And immediately I have moved the application for under 12A within 2 days. So we have got the invoices from major PSU creditors who are major PSU banks, but and the NCLT has asked directed for sending notices to all the creditors, all the stakeholders who are interested. How it is possible to send because it's a running company, it's an infrastructure company, and the creditors and operational creditors runs into thousands. How it is possible?
How it is possible is one part. How it is to be tackled is another part. I would suggest that with the help of some good counsel, we should prevail upon the Honorable NCLT that the decision about accepting 12A or not accepting 12A is left to the COC. So this is my list of creditors.
That is before forming of the COC, sir.
I'm only on that only, sir. I'm on that only. Claims are received. You have created list of creditors. COC will be formed after the list of creditors is prepared.
Only
list
within
of creditors. Sir, listen to me first.
Yes.
List of creditors is created on 21st day. That is different from formation of COC. So according to me, list of creditors will have to be prepared, given to the or presented before the bench that these are my creditors who are likely to be in the COC. This is the no objection received from these people, which is more than 90% of the future COC. So you should not ask me to go to other creditors which have no influence on withdrawal if COC is formed. the same will be applied before COC also. So that way it can be tackled. I am sure bench will agree to it. However, if you are saying that the list of creditors is not ready or cannot be placed before NCLT, I don't think that is the correct way.
Well, it is not just the list of financial creditors, sir. There will be operational creditors who will be supplying goods and services which will be
But
running.
they are not part of the COC in future. So the decision of 90% of withdrawal after COC is formed will be taken by only some of those creditors.
Only financial creditors.
Only those should be taken into account by Honorable NCLT, and we should be trying to convince that to the Honorable Bench, because according to me, this is a knee-jerk reaction from Honorable Bench after looking at the Baichu judgment. Everybody is worried how to address this. So many in many benches, even 6 to 8 months have passed, but there is no decision on failure.
Suddenly, during the hearing, one of the FC whose claim has there was a dispute among the CD and the financial creditor, and they have moved an there was an arbitral award also, which was given nil, both in favor of the in favor of the both the parties. Suddenly, the FC intervened during the hearing, and he said he have to court has to take his objection. But luckily, the court did not adhere to their objections and allowed the TOLE application based on the analysis given by the financial creditors.
That is good, sir. That is good. On the financial creditors who are non-related, who are in the COC, they should be considered according to me while deciding the TOLE. Others, objections they will file, they can be listened to. But if the law has to prevail, then only FC should be taken.
And even after rejection of their allowing the TOLE application, those financial creditor went to the NCLAT also. So apart from raising objection, they have a Section 7 application pending before the same NCLT. So the NCLAT did not dismissed the application, stating that since you already have a Section 7 application, you pursue that, and your rights are anyhow protected as they have filed appeal before Honorable High Court. Since your rights are protected and your Section 7 application is also pending with the NCLAT, so their application is not approved, admitted by the NCLAT. Recently, this happened last week only.
Right, sir. Good, sir.
Sir, there is a question.
That is before CISCA. Once CISCA has laid down the procedure much better, I think more people will start following the methodology used in CISCA.
Sir,
and one thing, as far as the how to intimate creditors, settlement is an initiative of the promoter. Who knows about creditor contact details than the promoter? Ask him.
Yes, sir. Bench 5 had started asking the IRP to send notices to all creditors. So, sir, everybody is following different methods. It has to be settled in a particular
way. No, the IRP may be sent under the hand of the IRP, but providing the information is the mandatory requirement. Otherwise, you tell the promoter, I won't place your 12A. अपने आप कर देगा, 24 घंटे में हो जाएगा.
So yes, there is one more question.
See, one has to use powers which are not necessarily specified.
What happens if applicant under